Hello, and welcome to HIPAA and IT. We're going to go over the HIPAA security rule and how it relates to you in your role as the IT professional. My name is Michael McCoy, and I will be your instructor today. First of all, understand this is not legal advice. We are not attorneys, and nothing we're going to say today is legal advice. However, it does come from the recommendations of the OCR, the Office for Civil Rights, who enforces the HIPAA rules and regulations. The HIPAA rules and regulations protect PHI, Protected Health Information. Protected health information can be in electronic, paper, or oral form. And basically, HIPAA PHI is an identifier matched with payment or treatment information concerning the patient. ePHI, Electronic Protected Health Information, is the term for digital patient information held in computers, thumb drives, backups, and other media devices. A key provision of the HIPAA privacy rule is the minimum necessary standard. The minimum necessary standard states that you may only use or disclose the minimum amount of patient information needed for its medically intended purpose. So yes, if necessary, you can be in a patient's chart, but that would need to be done when you are trying to fix something on the computer system. If possible, it would be best to use a demo patient if the problem can be duplicated there. And yes, the omnibus rule defines your role as a business associate. A business associate is any person or entity that creates, receives, maintains, or transmits protected health information, and that includes the network which holds the patient information. It is very important that you sign and have a business associate agreement in place with all of the covered entities, medical providers that you work with. You cannot limit or avoid regulatory liability just because you do not have that business associate agreement in place. Instead, you are violating federal law. From an IT perspective, we can put HIPAA into 4 words: encryption and comprehensive risk assessment. Encryption, all data at rest and all data in transit must be encrypted. Comprehensive risk assessment, all business associates and covered entities are required to have a documented risk assessment, comprehensive in nature, every single year to determine known vulnerabilities. As stated by the current OCR director, Jocelyn Samuels, organizations must complete a comprehensive risk analysis and establish strong policies and procedures to protect patients' health information. So a lot of HIPAA I can show you by recent Office for Civil Rights settlements with various covered entities and business associates. So in this case, Cancer Care had a breach of unencrypted patient information from a laptop. It contained the social security numbers, dates of birth, names, and addresses of about 55,000 patients. Cancer Care received a $750,000 fine. Now, Cancer Care, like all of these we're going to show you, you will see listed in the corrective action plan that the practice had not completed a comprehensive risk assessment. Here's where training is an integral part for both a covered entity and business associate to make sure their staff is fully aware of the current cyber risk. In this case, an employee downloaded an email attachment that released approximately 90,000 patient records. That firm was fined $750,000. St. Elizabeth's Medical Center is going to pay over $218,000 in part because their workforce members were using an inter-based document sharing application to store patient information. So if you know of any of your clients that are using internet-based cloud storage applications that do not have a business associate agreement with the vendor, they are risking huge fines. This practice also lost a USB flash drive that had additional unsecured electronic protected health information that was part of their fine. Part of your role as an IT professional is to help the practice identify where they have electronic protected health information. And in this case, the Office for Civil Rights fined Affinity Insurance $1.2 million because they failed to delete the hard drives on their copiers before returning them to the copier company. Again, part of the fine was because the organization failed to conduct an accurate and thorough risk analysis. If they had performed a risk analysis, they most likely would have implemented processes for accessing and monitoring all of their IT equipment. But because they did not perform that risk assessment, they did not implement security measures that were sufficient to reduce risk and vulnerabilities to its electronic protected health information to a reasonable and appropriate level. This fine is a good reminder that protected health information, even if it does not contain a patient's date of birth and social security number, can still cause major fines from the Office for Civil Rights. Here, this organization is going to pay $850,000 because a laptop was stolen. That laptop contained the CT images of approximately 599 individuals. In their corrective action plan, the Office for Civil Rights pointed out that they did not properly physically safeguard the workstation that contained the EPHI. There was also a lack of a unique user ID for identifying and tracking user identity with respect to the workstation that was at issue in this incident. So it is important that offices have unique user IDs for both Windows and their electronic medical record systems for tracking purposes. There are still many offices that are running Windows XP, even more that do not have a comprehensive patching program in place. In this settlement, OCR gave out a $150,000 fine because malicious software got onto a computer due to it being not properly patched. So do make sure that your clients know that this is a HIPAA requirement to patch software and to make sure that they are using only supported systems. This recent settlement shows again the cost for widespread non-compliance. SSS Management Corporation was fined $3.5 million, partially because of no risk assessment, partially because of a failure to implement the appropriate policies and procedures to protect patient information. There was also an impermissible disclosure to an outside vendor where they did not have a business associate agreement in place. most of what your organization is required to do is in the HIPAA security rule, and any privacy obligations are noted in your business associate agreement. You should note that as a business associate, you are required to perform an accounting of disclosures for any patient that requests. So an accounting of disclosures is any disclosure outside of payment, treatment, or healthcare operations that your organization may have. Now, more than likely, you will not have any accounting of disclosures and would have to state that to the patient. But it is important, if you have a breach of patient information, you must document the date of the disclosure, the name of the recipient if known, a brief description of the PHI that was disclosed, and the purpose of that disclosure. You are not allowed to charge for the first accounting of disclosures request per year. The privacy rule requires that you treat all information that you learn or see at covered entities as confidential, and never use your own access to peek into your record or family and friends records. In 2013, the Omnibus Rule updated the HIPAA standards. One of those updates were to require covered entities to provide patient information to their patients in digital format if it was requested. So the covered entities you work with must provide patients with their ePHI in whatever electronic format they can readily produce. That would include putting the information onto thumb drives because they have USB ports on their computers. However, they must understand that they cannot accept the patient's thumb drive. That thumb drive, as you know, could have any type of malicious software that could infect the entire network and cause a major release of patient information. So make sure that they understand this requirement, that this is a must, that they have to be able to provide electronic records in digital format, but they need to have policies and procedures that secure all of their medical records. So we recommend that what you do is have them purchase the thumb drive and then charge the patient for that device. Another part of the Omnibus Rule states that the covered entities must also email a patient's records to them. Now, we all know that this is an insecure method of transmission. It could be intercepted. I like to tell patients that it's like sending a postcard through the mail. Other people can read it. However, the importance here is to get the patients their records in the most convenient format available. And if email is that method, then we need to, or the covered entity needs to, warn the patient of the risk of it being intercepted or read, and if the patient accepts that risk, to document it in the email that the patient knew of and accepted the risk, and the practice must send the email even if it is not encrypted email. The Omnibus Rule also updated the breach notification rule. So what is a breach? How do you identify that a breach has occurred? Well, typically a breach is considered to be any violation of the privacy rule. So if somebody has seen patient information that violated minimum necessary, they did not have a need to see or a need to know, then you have a breach situation and it must be documented. So again, the omnibus definition of a breach, which changed the previous definition, is that any violation of the patient's information is a breach. There are 3 HIPAA exceptions to breach reporting. And they are typically if the information went to another HIPAA covered entity, if the information was seen by a workforce member or business associate of that practice. Remember, a business associate agreement must be in place for this exemption. If you are in the state of Florida, we also have a Florida rule called FIPA, the Florida Information Protection Act. It is more stringent than HIPAA and therefore must be followed. Those 3 exemptions that HIPAA gives are not allowed under the FIPA law. So the only FIPA exemptions are if the personal information was encrypted and if law enforcement documents that there is no risk of harm to the patient. The Florida Information Protection Act went into effect July 1st of 2014, so make sure that you are up on this. If you're in a state outside of Florida, make sure to check your local state's HIPAA or breach notification rules to ensure that you are not also under additional breach notification requirements. So in the event of a breach, you are required to fill out a security breach risk assessment. There are 4 questions that must be answered. They are the type of PHI that was exposed, who was it exposed to, was it actually seen or viewed, and what has been done to mitigate any harm that could come to the patient. Your job as a business associate is to report it to the covered entity, not to the patient. Remember that under HIPAA, even a suspected breach is an actual breach until we fill out the breach security risk assessment to determine that no breach has occurred. So breach costs can be staggering. And the other thing about breaches is they now account for about 10% of them are through hacking attacks. If the breach or suspected breach was a virus or other malware, then the breach security computer incident reporting form needs to be filled out. To determine the extent of the breach or that no breach occurred, we must detect what type of virus or malware was infected and what that malware can do. We can determine that through the national database. And then we may also have to go into forensic IT to determine, did that virus or malware do what it could do? These questions must be answered each time the network has a virus or other malware detected. Once completed, this form needs to be given to the covered entity's HIPAA compliance officer. The HIPAA security rule. All covered entities and all business associates are covered by the HIPAA security rule. There are no exemptions. That means every business associate must have a risk analysis in place, must have a risk management program. These are the required standards for all entities covered by the HIPAA security rule, no exemptions. The HIPAA security rule has required and addressable standards. Required means it's required. Addressable means it's required. Or you must, in great detail, document your reasons for using an alternative method of security and making sure that that security is just as good as the addressable standard. So here's the good example. Is there anything that is protective as encryption under the HIPAA security rule. It would be difficult to argue that any other measures you put into place have the effect of encryption, which is a safe harbor to the breach notification rule. So even though encryption is an addressable standard, it is required. Again, all business associates, just as all covered entities, must have a yearly updated risk assessment looking for known vulnerabilities. Once found, the risk management report puts together a plan to correct those vulnerabilities. Sanctions are a part of the HIPAA security rule. You must be able to show the Office for Civil Rights that you have an ongoing compliance program. There will be violations of your policies and procedures, and to show that you have a culture of compliance, the sanctions report shows that you have identified those violations and worked to correct those violations. HIPAA also requires monitoring of the systems that access and contain electronic protected health information. So system activity reviews are required, not only by the covered entity, but to any access that you may have as well. That would include audit log reporting, fax log reporting, and penetration reports. Again, these security activity reports show that you have a culture of compliance, that you are ongoing monitoring of patient systems to make sure there is no unusual or suspicious activity. And again, if it's not documented, it's not done. The security rule also requires adequate protection against malicious code. That's going to include commercial grade firewalls with updated intrusion detection and prevention systems and unified threat management systems, commercial grade antivirus and anti-malware, routine vulnerability scans and the remediation of the findings of those scans, and of course patching of the servers and patching all the way down to the workstations for your organization and for the covered entities organization. Additional security rule protections would include making sure that the wireless network is running WPA2 or better. And best practices now includes MAC address filtering, training of the workforce, making them understand good computer security, spam filters to help protect the practice from those unwanted emails, and internet restrictions and the monitoring to make sure that the employees are adhering to those restrictions. Each covered entity and your business associate organization should have a network diagram showing the location of electronic protected health information and the protections surrounding that information. On the computers, make sure that login monitoring is turned on. In Windows, make sure to turn on login success and failure monitoring. A great program to determine whether or not this feature is turned on is Microsoft Baseline Security Analyzer. Run it on each workstation to ensure that Windows and Office patches are in place and that this login monitoring is turned on. The default is not to have it turned on. Also make sure that security incident procedures are in place, such as breach reporting. Contingency planning is a huge part of the HIPAA security rule. So make sure that there is data backup and recovery procedures in place. Make sure that that backup is tested on a routine basis to ensure that it can provide the exact backup. You should also have on-site and off-site backup if available. Disaster recovery operations, emergency mode operations, and an analysis of how critical your applications and data is. A reminder, if you are a business associate and do not have a business associate agreement in place, you are in violation of a federal law that has a fine of up to $1.5 million per occurrence. So make sure if the covered entity has not given you a business associate, you give one to them and make sure it gets signed. Also, should you hire any subcontractors, remember that the covered entity is responsible all the way down the line, even for your subcontractors. So make sure that you do due diligence on your subcontractors to make sure that they are HIPAA compliant. HIPAA, again, is about documentation. That is how you show your compliance to the Office for Civil Rights. And when electronic media is disposed of, HIPAA requires that the person disposing of it certifies that it has been done to the HIPAA administrative rules. So this form will allow you to certify not only that it was destroyed to the Department of Defense standards, but also with the HIPAA administrative requirements. Other HIPAA security rule requirements are that there are integrity controls in place to make sure that the information is not altered, automatic log off after a period of inactivity for both the EHR system and Windows, and of course person and or entity authentication. Make sure that each user for both Windows and the EHR has their unique user ID. Therefore, we can have accountability and make sure that there is good inventory control, asset tags on all the equipment, and updated inventory control sheets. It is oftentimes difficult to get staff members to understand the need for complex passwords. However, if you can explain to them that most passwords are already known, in fact, if you take the top 10,000 passwords, you will have 99% of the passwords that people use. Here's a list of the 2015 most common passwords. Password 123456, and monkeys in that list as well. Encryption. It is the key